Good day, ladies and gentlemen. I am Jamila Jimba, and today I will be discussing Articles 2 to 11 of Act Number 3815, otherwise known as the Revised Penal Code of the Philippines.
Article 2. Except as provided in the treaties and laws of preferential application, the provisions of this code shall be enforced not only within the Philippine archipelago, including its atmosphere, its interior waters and maritime zone, but also outside of its jurisdiction against those who There are two rules as to crimes committed aboard foreign merchant vessels, the French rule and the English rule. The French rule is such crimes are not triable in the courts of that country unless their commission affects the peace and security of the territory or the safety of the state is endangered. English rule, on the other hand, such crimes are triable in that country unless they merely affect things within the vessel or they refer to the internal management thereof. In this country, we observe the English rule.
Under international law rule, a vessel which is not registered in accordance with the laws of any country is considered a pirate vessel, and piracy is a crime against humanity in general, such that wherever the pirates may go, they can be prosecuted.
Article 3. Acts and commissions punishable by law are felonies. Felonies are committed not only by means of deceit or dolo, but also by means of fault or culpa. There is deceit when the act is performed with deliberate intent, and there is fault when the wrongful act results from imprudence, negligence, lack of foresight, and lack of skill.
While ignorance of the law excuses no one from compliance therewith, ignorance or mistake of fact relieves the accused from criminal liability.
Article 4. Criminal liability. criminal liability shall be incurred by any person committing a felony, although the wrongful act done be different from that which he intended.
For example, injuring one person who is mistaken for another. I intended to shoot B, but he instead shot C, because I mistook C for B. In this instance, the offender can still be held criminally liable, since he is motivated by criminal intent.
By any person performing an act which would be an offense against persons or property were it not for the inherent impossibility of its accomplishment, or on account of the employment of inadequate or ineffectual means. Article 5. Duty of the court in connection with acts which should be repressed, but which are not covered by the law and in cases of excessive penalties. Whenever a court has knowledge of any act which it may deem proper to repress and which is not punishable by law, it shall render the proper decision and shall report to the Chief Executive through the Department of Justice the reasons which induce the court to believe that said act should be made subject of legislation. In the same way, the court shall submit to the Chief Executive, through the Department of Justice, such statement as may be deemed proper, without suspending the execution of the sentence when a strict enforcement of the provisions of this code would result in the imposition of a clearly excessive penalty, taking into consideration the degree of malice and the injury caused by the offense. Article 6. Consummated felonies, as well as those which are frustrated and attempted, are punishable. A felony is consummated when all the elements necessary for its execution and accomplishment are present, and it is frustrated when the offender performs all the acts of execution which would produce the felony as a consequence, but which, nevertheless, do not produce it by reason of causes independent to the will of the perpetrator. There is an attempt when the offender commences the commission of a felony directly by overt acts and does not perform all the acts of execution which would produce the felony by reason of some cause or accident other than his own spontaneous existence.
A put poison in B's food. B threw away his food. I is liable. It's attempted murder. The attempted stage is said to be within the subjective phase of execution of a felony.
Article 7. Light felonies are punishable only when they have been consummated, with the exception of those committed against persons or property. Article 8. Conspiracy and proposal to commit felony are punishable only in the cases in which the law provides penalty therefor. A conspiracy exists when two or more persons come to an agreement concerning the commission of a felony and decided to commit it. And there is a proposal when the person who has decided to commit a felony proposes its execution to some other person or persons. Article 9. Grave felonies are those to which the law attaches the capital punishment or penalties which in any of their period are afflicted in accordance with Article 25 of this Code. Less grave felonies are those which the law punishes with penalties which in their maximum period are correctional in accordance with the above-mentioned article. Light felonies are those infractions of the law for the commission of which the penalty of arresto mayor or a fine not exceeding 200 pesos or both is provided. Article 10. Offenses which are or in the future may be punishable under special laws are not subject to the provisions of this code. This code shall be supplementary to such laws unless the latter should specially provide the contrary. Article 11. Justifying circumstances. Those wherein the acts of the actor are in accordance with the law, hence he is justified. There is no criminal and civil liability because there is no crime. Number 1. Anyone who acts in defense of his person or rights provided that the following circumstances concur. First, unlawful aggression. Second, reasonable necessity of the means employed to prevent or repel it. And third, lack of sufficient provocation on the part of the person defending himself. Number 2. Anyone who acts in defense of a person or right of his spouse, ascendants, descendants, or legitimate, natural, or adopted brothers and sisters, or his relatives by affinity in the same degrees and those consanguinity within the fourth civil degree, provided that the first and second requisites prescribed in the next preceding circumstance are present, and the further requisite in case the revocation was given by the person attacked that the one making defense had no part therein. Number 3. Anyone who acts in defense of the person or rights of a stranger, provided that the first and second requisites mentioned in the first circumstances of this article are present, and that the person defending be not induced by revenge, resentment, or other evil motive. Number 4. Any person who, in order to avoid an evil or injury, does an act which causes damage to another, provided that the following requisites are present. First, that the evil sought to be avoided actually exists. Second, that the injury feared be greater than that done to avoid it. And third, that there be no other practical and less harmful means of preventing it. Number 5. Any person who acts in the fulfillment of a duty or in the lawful exercise of a right or office. Number 6. Any person who acts in obedience to an order issued by a superior for some lawful purpose.